Hi, everyone, and welcome to this latest Pepper podcast. Today, I'm joined by two leaders of Pepper's higher education practice. Please welcome Pepper partners Michael Baughman and Kristin Jones. Folks, welcome.
Hello.
Hi.
Title IX guidance and enforcement were a major focus of the Obama administration, and we are sitting after the 100th day of the new administration, and most members of the higher education community still are wondering if we will continue to see the same level of regulatory enforcement as the prior administration. Open question to you two. What have we learned about the future of the Department of Ed and Title IX in these first 100 days? Michael, let's start with you.
So to be honest, I don't think we've learned a whole lot about how the Department of Education is going to turn out in the Trump administration in these first 100 days. They've frankly been slow to take action. There was a initial action that was taken early on that revoked the guidance that was issued on transgender bathrooms, but that wasn't really much of a surprise since Trump promised to do that on the campaign trail. And I think we're still waiting to see what the department is going to do over the next 100 days.
I think at this point, there's probably more questions than answers. So for instance, President Trump appointed Jerry Falwell Jr. to run an education task force. Falwell has expressed a lot of concern publicly that colleges and universities are overregulated, as well as, a lot of interest in eliminating some of the burdens imposed by Title IX. But to date, we haven't seen anything out of that task force.
And we do know this is something that is on the president's agenda, at least, because very recently, I guess last week on April 26th, President Trump ordered the Secretary of Education to review the government's role in school policy. So he gave her 300 days to review and, if necessary, modify and repeal regulations and guidance issued by the Department of Education, with a mandate to identify places where Washington has, frankly, overstepped its legal authority.
There is a congressman from Kentucky who introduced a bill that would abolish the Department of Education by the end of 2018. We don't see that bill going anywhere.
So I think the bottom line is a little early to tell how the Department of Education is going to turn out under the Trump administration after the first 100 days, which is probably consistent with generally how his administration has gone so far.
I think the next 300 days might be more interesting as Secretary DeVos undertakes her review.
Now, Michael, you did mention this under Secretary DeVos. Does the Department of Education's February 22nd Dear Colleague letter offer any other insights?
Well, I think, to me it wasn't a surprise that guidance was repealed because, again, President Trump said he was going to do that on the campaign trail. And frankly, that was pretty recent guidance. It had just been issued a few months before. It was subject to litigation. It was, frankly, highly controversial. So that wasn't necessarily much of a surprise. But I do think we can take some of the reasoning of the letter to suggest maybe a course for how this department is going to interpret things going forward. Right, Chris?
I agree. The reasoning for the rollback of the May 2016 Dear Colleague letter was that the guidance on transgender student access to school facilities was legislative and substantive and should have been the subject of formal rulemaking, and that there should have been notice and comment rulemaking prior to the adoption of any such policy. This same logic could arguably apply to the other Dear Colleague letters, the April 4th, 2011 Dear Colleague letter, and the subsequent Title IX guidance documents issued by OCR, like the Q&A. Now, it's important to remember that a lot of the Title IX guidance has been made law through, for example, the amendments to VAWA, but it will be interesting to see for those pure policy and guidance documents what their fate is, under this new view.
And unlike the transgender bathroom guidance, which had just come out sort of at the end of Obama's administration, the Title IX guidance has been in place for many years now, and schools have taken a lot of action to implement the guidance, and OCR has been aggressive in enforcing the guidance. So to me, if the Trump administration is going to try to backtrack on that guidance or repeal that guidance, it might be a little bit tougher given how long that guidance has been in place and that it's been consistently enforced for 6 years or so.
These same issues that we're talking about, the need for formal rulemaking, they're being litigated currently in the federal courts. There is a lawsuit currently pending in the District of Columbia challenging the validity of the Dear Colleague letter. So we are watching that closely.
And the Dear Colleague letter also comes up in the context of some of the civil Title IX litigation going on right now, both brought by complainants and respondents, where courts are being asked to basically apply the Title IX guidance as the standard of care. and courts are sort of coming out in different directions on that. But, bottom line is the courts could have something to say about the authority of the Department of Education to issue this guidance as well.
It's really unclear, if there is going to be a rollback on guidance, by the Department of Education. The impetus for rolling back the policy and guidance issued by the Department of Education could come from the courts, either in a direct challenge or as part of the civil litigation that Mike was just talking. Or, as we started with, it could come from Secretary DeVos and the new administration. We know that Secretary DeVos shares President Trump's view that Title IX issues are best resolved at a state and local level.
And then even if the guidance isn't rolled back, which my guess is it's sort of unlikely that will happen given how long that guidance has been out there, the real question is how aggressively is the Office for Civil Rights going to enforce the guidance that's in place? We know that under the Obama administration, not only did they aggressively enforce the guidance, but they issued very long letters of finding, very long resolution agreements where they, very clearly stated their position on whether schools had complied with Title IX or not. It'll be interesting to see if that path continues under the Trump administration.
Now, I know you both are traveling the country a lot and talking to our college and university clients. What are your recommendations to them right now on the future of Title IX and the 2011-2014 Dear Colleague letters?
Yeah, I think my advice is that's the law, and I wouldn't expect that it to change anytime soon. And, again, I don't see our clients sort of changing what they have done over the last 5, 6, 7 years on the Title IX front, whether that guidance has changed or not. Chris, what do you think?
I think we have to assume right now that our clients should stay the course and continue with the initiatives and the policies that they've put in place, over the course of the last 6 years. Certainly we see OCR maintaining what we think is a business as usual stance. That is, on April 19th, OCR officially opened 8 new Title IX investigations. In March 2017, OCR announced the resolution agreements with Wittenberg University and the Palo Alto Unified School District. The month before that, in February, OCR announced a resolution agreement with the University of Alaska. The Wittenberg resolution, now granted that could have been underway during the Obama administration, but it's virtually the same in tenor and aggressiveness as the resolution agreements that we saw over the course of the last few years. So, I think OCR may also be waiting for a signal on how it should be proceeding.
Yeah, and clients in assessing sort of the risk issues under Title IX, the Department of Education is really only one variable in that equation. First of all, the students and faculty at our clients are demanding that schools aggressively tackle issues of sexual misconduct on campus, as they should be. And, our clients need to be responsive not only to the Office for Civil Rights, but to their constituencies on campus as well. And, whether or not the administration is going to aggressively enforce Title IX, one thing we are certainly seeing, and has not waned at all since the Trump administration took power, is civil lawsuits. And, I think there was an article in the Washington Post over the weekend about the increase in respondent lawsuits. We've certainly seen an increase in complainant lawsuits as well. So, whatever the regulatory guidance is, schools need to, be very careful in how they apply their policies to avoid civil liability as well.
Now, what would the effect be if the OCR scaled back its enforcement?
Our hope would be that perhaps those resources would be reallocated, that instead of targeting schools and doing a look back, that OCR would partner with schools and look forward and figuring out how, working together, they can address issues relating to sexual misconduct on college campuses.
Yeah, I would agree with that, and I think that schools are going to continue to take this issue seriously, as they should, whether the administration is enforcing it or not.
Well, this is definitely an evolving area of the law, and we're running out of time today, but we'll check in with you in a few months to see how things are going then. Right now, as we say, we're running out of time. I want to thank you for the time you gave our listeners. And for our listeners, if you're interested in signing up for higher education alerts from Pepper Hamilton, feel free to email me at dolanb@pepperlaw.com for future updates. My email address is also where this podcast is listed on Pepper's Insight Center at www.pepperlaw.com.